All right, good evening, everyone. I'm going to call the meeting to order at 5:34 p.m. Thank you all for coming. We're going to do roll call first.
Dejan Kane, Deborah Kosikowicz,
Here.
Joanne Anderson,
Here.
Maya Rasdin,
Here.
Tyquin Forbes.
Present.
Chair, you have a quorum.
All right, we've got a quorum. That is good news. Thank you very much, Kayla. So now we're going to do an adoption of the agenda. I have a motion to adopt the agenda for today.
I move to adopt the agenda.
Okay, we have a motion. Do we need a second?
I'll second that.
Okay, we have a second to adopt the agenda. And now we go on to approval of the minutes. You have them in front of you. Board members, September 21st, our last meeting for last month. Do we have a motion to approve the minutes for September 21st?
I move to approve the September 21st meeting minutes.
Okay, do we have a second motion to approve?
Second that.
All right, very good. We've approved the minutes for September 21st. I'm going to ask if there's any public comment from those sitting out in the gallery.
We're waiting on the case, right? Okay.
Okay, no public comment. So then we'll move on in the agenda to the OEI Director's update.
No update tonight, Chair.
No update?
I'm sorry, Vice Chair. I apologize.
Thanks. All right, since we have no update, we'll go on to old business discussion items. Well, we have case EOE-2022-07.
Thank you, Vice Chair. The Equity and Inclusion Office has provided the members of the Human Rights Board a written report concerning a complaint of discrimination in EO-E-2022-07. We have processed the complaint as required by Chapter 8 of the City's Code. We are here today to report our findings as to whether reasonable cause exists to believe that an unlawful discriminatory practice has occurred in accordance with the City of Gainesville Code of Ordinance, Section 8-88, paren A, paren 4. We are now ready to report the results of our findings concerning a complaint of discrimination in EO-E-2022-07.
Members of the board, thank you for your presence and participation. You've each received a copy of the final investigative report for complaint EO-E-2022-07 and have had time to review the findings. I will now summarize the findings as it relates to this case. Complainant's allegations. Complainant alleged respondents filed an eviction against her and issued a non-renewal due to her use of a lawful source of income. Respondent's position. Respondents did not discriminate against complainant. Respondents stated they were willing to dismiss the eviction except the rental assistance, if not for complainant filing a countersuit. Respondents stated they issued a non-renewal notice due to harassment of staff. Summary of investigation findings. For complainants to succeed in her claim of housing rental denial based on lawful source of income, the investigation must establish the following. 1, the complainant is a member of protected class. 2, complainant was the respondent's tenant. 3, respondents acted to terminate the complainant's tenancy, for example, by initiating eviction, sending a notice to terminate, or refusing to renew complainant's lease. 4, respondents did not take similar action against a tenant of a different protected class, or the dwelling remained available thereafter. The first element was met as complainant was an applicant and recipient of rental assistance from a federally funded emergency rental assistance program. The second element was met as complainant was respondent's tenant. The third element was met as respondents acted to terminate complainant's tenancy by filing an eviction on August 4th, 2021 due to rent owed. Also, respondents chose not to renew complainant's lease on March 2nd, 2022. With regard to the fourth element, the tenant who received rental assistance prior to complainant, tenant A, did not have an eviction filed against them, and the majority of the tenants who received assistance after complainant did not have an eviction filed against them. The evidence provided in an email that respondents informed the county they were willing to cancel the eviction and accept rental assistance on complainant's behalf. However, a few days later, respondents received notice of complainant's countersuit and decided to proceed with the eviction. Based on the evidence provided, it can be concluded that respondents waited a reasonable amount of time before filing an eviction against complainant, In addition, respondents stated they were willing to dismiss the eviction and accept the rental assistance if not for a complainant filing a countersuit. Based on the history provided, respondents accept ERAP funds. There is no clear evidence that respondent did not accept complainant's ERAP funds due to discrimination. Therefore, this concludes the examination of complainant's discrimination claims regarding her eviction. In evaluating the non-renewal, respondent stated complainant's non-renewal was due to harassment of staff. Respondent provided copies of various emails in which complainant complained about the unit and the conditions of the property. Respondents provided evidence that they also issued a non-renewal notice due to harassment of staff to tenants who did not receive rental assistance. The facts presented demonstrate this is a landlord-tenant dispute that does not give rise to a claim of discrimination. As a result, this concludes the examination of complainant's discrimination claims regarding her non-renewal of lease. Therefore, based on the foregoing, there is no reasonable cause to believe respondents violated the Code of Ordinance of Gainesville, Florida, Section 8-88A4.
As indicated in our written report, we have determined that there is not sufficient information that would lead an impartial observer to believe that a discriminatory practice has occurred. If you do not believe that there is reasonable cause to believe that a discriminatory practice has occurred, the Equal Opportunity Director must dismiss the complaint. You also have the discretion to, by a 3/4 majority vote, order such further investigation as deemed necessary. Your decision should be based on the evidence of record. Vice Chair, as required, we have provided the board with evidence concerning our investigation of complaint of discrimination in EO-E-2022-07. You must now make a determination based upon that investigation and the evidence of record.
Thank you very much. All right, members of the board, you've had the opportunity to read the investigative report that is concerning the complaint of discrimination EOE-2022-07 and heard the summary of that report provided by the compliance investigator. What questions, if any, do you have concerning the report? And remember, any questions from the board members should be directed to the vice chair. Anyone with any questions?
I know that last meeting there was a question about conflict of interest. Did we get an answer back on that matter?
Yes, there is no conflict of interest.
Thank you, Michelle. Any other questions? All right. We are now going to offer parties the complainant and respondent privileges of the floor. You will have a limited amount of time to debate when the occasion warrants, but such limits shall be equal for all parties. Each party has the floor for 3 minutes. Is there anyone? Start with the complainant. Okay.
Is this working? Okay, I'm sorry, guys. Thank you for having me here tonight, and thank you again for being here to listen to me. My name is Carrie Sadis, and I am a person with legally recognized disabilities. I was a tenant of Hunter's Run for nearly 6 years. I became unemployed during the pandemic. With the assistance of the State of Florida Vocational Rehabilitation, I am now fully employed in fraud prevention as a Medicare coverage analyst. However, due to my increased stress and anxiety continuing by this incident, my learning capabilities were impaired, and I am under a professional improvement plan with my workplace. I am here today because I have been discriminated against, and the tool used to discriminate against me was refusing to accept and apply my ERAP funding, which is my source of income. I ask that you bear with me as I provide a short summary of the circumstances surrounding my complaint. At the beginning of July 2021, unable to pay rent, I fell into arrears and became eligible for ERAP assistance. Hunter's Run and I applied jointly for the ERAPs. The declaration of the agreement signed by Hunter's Run to receive ERAP funds on behalf of tenants includes a 45-day eviction moratorium. In spite of this, and contrary to the written assurances they provided, after weeks, Hunters served me an eviction notice. On the same day, Hunter's Run and I were notified that I was approved for funding. As a result, I had to take legal steps to protect myself and respond to the eviction. Only after Hunter's Run learned that I hired an attorney did they inform the county ERAP on Monday, August 16th, 2021, that they would dismiss the complaint, but they failed to do so. By Hunter's Run not dismissing this complaint, I was put in a catch-22. If I did not respond to the complaint within the statutory deadline, I would have been in default and left without resources, and my EREP was being dispersed to Hunter's Run. If I failed to counterclaim, I would not have been able to hold them accountable and recoup any legal fees that I already had to borrow. The reaction from Hunter's Run in my actions was malicious and retaliatory. My EREP funds were dispersed on August 18th, paying Hunter's Run for all the arrears, as well as guaranteeing payment rent through December 2021. Despite being paid and agreeing to the county EREP, me, Hunter's Run, refused to accept my lawful source of income and dismiss their complaint. Instead, they opted to return my lawful source of income to the EREP funds and to the county on November 1st. The city investigation concludes that this is merely a tenant-landlord dispute. These actions are the jurisdiction of the pending tenant-landlord dispute. However, refusing to accept and apply a lawful source of income, which is my EREP funding, is a violation of 888-884 and the jurisdiction of this body. I therefore ask that you hold them accountable and find that they have discriminated against me by failing to accept the lawful source of income and apply it to my rent. I can produce these documents as request. Thank you for your time and attention in this matter.
Thank you very much, Ms. Davis. Is there anyone else who would like to speak on the respondent's behalf? Do we have anybody online, or is someone here?
I'm so sorry. What was your question?
No, we gave you 3 minutes, and so we're asking for the respondent. If there's anyone from the other party.
Oh, that's
Sorry.
what I thought. You
Yes.
wanted. Sorry.
No, you're fine. You're fine. Thank you so much. Please, sir.
So anybody else now?
Are you from the respondents?
No, I'm not.
Okay.
No, we don't have anyone from the respondents.
We don't have anyone from the-
To the other individuals.
No, it's just 3 minutes on behalf of the charging party,
Yeah.
period.
So then, if they bring people for them to speak, they can't speak during the case review?
No, it's just 3 minutes for each party.
Would they be able to speak during public comment?
I don't know the answer to that question. Public comment is something new in these meetings that we've just started.
So, I'll defer to Jerome.
Vice Chair and Board, the complainant has utilized her 3 minutes and has shared information. Do you have any questions based on what she shared?
I have a question. The complainant says that she and the respondent signed a 45-day stay on eviction, but I don't think they waited 45 days to issue the eviction. Do we know if that agreement was binding, or has the investigator seen that agreement that the complainant's speaking about?
Yes, she is speaking about the application, and the eviction was filed before the funds were received. So in the application, it says that the funds have to be received before that 45-day eviction moratorium goes into place.
I'm sorry, I'm not to disagree with you.
So the application says, give us 45 days to disperse the funds?
The application says you have 45 days after the payments have been received. That's the language. But the payments haven't been received. When the eviction was filed, she hadn't been approved. The application was still under review.
And the ERAP says that that was just, part of the process. It takes a little while sometimes.
They said that they were still reviewing her application and that it still could take up to a few weeks before they give a response. So the respondent decided to go ahead and file an eviction. Now, the key part of this case is the comparators. There were individuals before and after the complainant who had received rental assistance, but they didn't have an eviction filed against them. So down in the finding section, that's what the determination was based on, the comparators in the situation. Individuals who had received rental assistance, they were not had an eviction filed against them.
Right, and I agree with that. The comparators make sense to me. I guess because the 45-day part wasn't included in what I have in front of me, I'm asking specifically if the investigator can answer if the eviction was filed within the time frame they're talking about, or if it was filed after the time frame that was talked about in the application.
The application fee references once the money has been awarded.
I'm so sorry, Shaquilla, that is incorrect. The application states, bullet number 3, for the representative of the landlord states, there is a 45-day eviction moratorium for every single month that a payment should be paid. And within that time frame, it says nothing about the regards to having to pay it, because with due respect to the federal monies, it has to go through multiple hands to be able to be then dispersed, which is why the 45-day eviction moratorium is in the county's ERP. However, legally in the federal law, it says 90 days. On behalf of the federal funds for the ERP, 90 days is recommended because typically an awarded person is not even actually awarded for a minimum of 45 days. I was awarded in 28 days. My application went in by the landlord on July 7th. I was approved on the 10th of August. And in fact, it was approved prior to that, but they are not able to tell me, the ERP program is not able to tell me from the August 2nd when they asked for a secondary review, and ERP provided that, compared to the time frame of the 10th when I received the official email, because there's a portal called Neighborly Portal. The Neighborly Portal is shared by the tenant and the landlord and the ERP. It is a fully functional, graphical picture of when your money is done. And on July 16th, which the report does not provide, Hunter's Run provided me an email that said, I see that your funding has been set aside through December 2021. I hope this provides you less stress. It will take some time for the money to come in because the first tenant that received these funds, it took some time. We are willing to be patient and wait with you. Those were not exact words, but I can provide you those words. The application for ERP is very extensive, and the signature of a 45-day eviction moratorium is for the landlords because of the fact that federal funds are very long and extensive in terms of the approval. The secondary review is based on the fact that the landlord provides how much my rent is, how much I'm in arrears, and how much will ultimately get paid. It's a lump sum payment for 3 months first, then every 19th of the month, your following month rent is paid.
I stand by my statements that in the application, it says that the funds have to be received. Then the 45-day eviction moratorium goes into place. Considering all of the evidence of record here, when you look at comparators, as well as the treatment that she has received, it doesn't point towards discrimination based on lawful source of income. Now, the comments about federal eviction moratoriums and things of that nature, that's not within our jurisdiction. We enforce Chapter 8, which is about discrimination. And reviewing all of the evidence that was provided, the landlord filed an eviction before she was approved or denied.
So, Kayla, I have a question. What is the fourth element?
The fourth element is respondents did not take similar action against a tenant of a different protected class or the dwelling remained available thereafter.
Why wasn't the fourth element met?
The fourth element wasn't met because the comparators, individuals within the complainant's protected class, they were treated in a different manner than she was. Individuals that had also received rental assistance, they didn't have an eviction filed against them. Out of all the individuals that were provided, they still remained at the apartment complex, and the complainant was the only person that had an eviction filed against them.
Doesn't that mean that I was discriminated against?
The other individuals also had rental assistance, but they didn't have an eviction filed against them. So when you look at the fourth element of this case, when evaluating whether similar action was taken against tenants of a different protected class, you look at the individuals within your protected class, they didn't have an eviction filed against them. So they're comparable to you because they had rental assistance as well.
Well, and the only difference would be, in my understanding, correct me if I'm wrong, is that the comparatives had approved rental assistance.
Eventually they were approved, yes.
Okay. So they weren't approved at the time and with no eviction notice.
They didn't have any eviction filed against them.
Right, but they weren't approved. They were in the process just like she was.
They went through an application process similar to the complainant. So in that, they didn't have an eviction filed against them. They're comparable to her because they received rental assistance as well. And they
Eventually.
applied.
But
as
during
well.
the process,
Correct.
they weren't approved.
During the process, there was a period of deciding whether or not they would be approved, but in that process, an eviction was not filed against them.
And for the complainant, there was.
Correct.
So I see the comparative, but it's different.
What do you mean it's different?
She was in the process of filing an application as well with no approval and not being declined, just as these others. She was served an eviction. These others were not.
But if they were discriminatory against individuals that received lawful source of income, the other people would have been treated the same way because they had an application period as well. So during that application period, an eviction should have been filed against them if they were treated in the same manner as the complainant. But
They weren't. That's different. That's what the discrimination is, right?
No, I think
No.
what she's trying to say is, we investigate Chapter 8, and the fourth element was not met because people who received lawful source of income were not discriminated against as a whole.
But that was eventually decided. But at the time, in the process, whether before being approved or denied, just as the complainant, they were not served an eviction, and she was.
Correct.
That's different.
Correct. However,
Okay. I
because
just want to make sure I understand that. Is that how it?
you,
I'm
yes,
understanding
you
it?
can
Okay.
understand that. I think one of the
Okay.
things is to keep in mind is that we're looking at discrimination on the basis of lawful source of income. Why a landlord decides to evict or not renew with a person is not per se in our wheelhouse. We're looking to see if there was discriminatory action that occurred.
But if they're both in the same process,
You can be in the same.
and they both have not been approved or denied,
Then all of them should have an eviction filed against them if they're all being discriminated against based on lawful source of income.
but she's the one that filed the complaint. The others have not. We're using that as a comparative. So that's
Right,
being treated
so-
differently because she is on that end of receiving an eviction at a detriment and the others did not. That's difference of treatment, which would not be defined as discrimination.
Not
No.
based on lawful source of income.
But they didn't have that lawful source of income obtained yet. They weren't approved
Neither-
or
They were-
denied, and neither was she.
They're similarly
Correct.
situated to her because they went through an application process as well. If there were 2 or 3 other people who, while they were waiting on the assistance, had an eviction filed against them, this case would lead more towards discrimination. But given that all of the individuals who've received rental assistance and gone through the application process similar to the complainant didn't receive that treatment, it doesn't lean towards discrimination.
I have
It
a
only
question.
takes one, though.
I have a question. Do we know if the people we're comparing to, the comparators, were they trying to draw on the same sort? Because my understanding is that the complainant was trying to draw on a federal rental assistance program. Do we know that the other comparators were also trying to draw on a federal one? Or were those like more county or state?
Yes, they were all federal monies for rental assistance.
Okay, thank you.
Yeah. The other thing is, again, I want to make sure I say it. Chapter 8 doesn't prevent landlords for not renewing. Chapter 8 doesn't say that landlords have to renew a person. So it allows for a landlord to evict, to decide not to renew anyone, right?
Sure, absolutely. I agree with that.
We're looking at just lawful source of income. Period. Was there discrimination based on lawful source of income? Was there discrimination based on everybody being blue? Everybody being red? Everybody having a white dog? You know what I mean? So
But it starts with one, and that's you know, you may not have 4 or 5 others, but it starts with one. And here you have individuals that are in the comparative that are in the same process as the complainant. They're not either approved or denied yet funding. Nothing has been received for either of those cases, any of those comparative cases. And yet one is treated differently than the others.
And first of all, that's not our prerogative because, again, we're just focusing on lawful source of income. But again, we don't know the other factors of why a landlord chooses to renew somebody or they don't.
I want to say that when we're looking at these cases, when there are comparators, you're looking for a pattern. This case didn't have a pattern. I looked at the other individuals who applied for rental assistance. They went through the application process, and in that application process, the respondent could have went and filed an eviction because technically they hadn't received any money and individuals owed rent. However, no eviction was filed. Only in the complainant situation was an eviction filed. So when you look at what happened before the complainant and what's happened after the complainant, there's no pattern and there's no, it doesn't point to lawful source of income being the reason why she was treated differently.
But I totally get what you're saying in looking for a pattern, but it always starts with one, because you can't have a pattern unless you start with one.
And if I might add, and I do apologize, because this has been 435 days for me. And you were the first people to hear my case. And I am going to say this again. This is a lawful source of income. And as we stand here today, Hunter's Run has taken everybody's lawful source of income. In terms of the eviction, that is not up to this board or the investigation to decide that. That is up to the judicial system and the judge who sits there and holds it. It is not being seen over there at the judge. I will not go into that information. However, my source of income is consistently and been told in this investigation that we will not take her funding because she counterclaimed. We will not take her funding because she went against us. That's what they've said twice in the investigation. This is my source of income, just like everybody else's. Theirs was taken, mine was not. It still was not taken. I've asked, just apply my source of income to my rent. That is the purpose of the Emergency Rental Assistance Program. It is to keep people in their home during the pandemic. I was not only unemployed for 8 months and deserving of the money in past, it's also money that has never been used to what it needed to be used, yet everybody else's was, if theirs was the federal funding of the Emergency Rental Assistance Program. It is about the source of my lawful income, not about the eviction, not about my renewal. I didn't renew. I will not renew with a company that will not take my rental funds. And those other folks, money was taken. Why? Why was theirs and why was mine sent back to the ERAP in violation of the ERAP agreement?
I can make a comment to Deborah. I heard you say that, it starts with, but I wanted to point your attention to page 3 of the respondent's position of the investigative summary. That third paragraph there, it says that 4 other comparative tenants received federally funded rental assistance after tenant A, after the complainant. So I just wanted to point out that it's not actually a starting with situation.
No, well, I mean, I totally get what you're pointing out, and I appreciate that.
So the-
But it starts somewhere. If you're gonna see a pattern anywhere, has to start somewhere. And that's using that not in this specific situation, but in any situation or occurrence. If you're looking for a pattern of something, it has to start somewhere.
So let's
I guess I'm having, some question about.
I'm sorry, did you?
No, go
Okay, I
ahead.
wanna make sure I didn't cut you off.
Sure.
Going back to the comparators, when you look and see with this case, have they accepted rental assistance funds? The answer is yes. They accepted it before the complainant and they've accepted it after the complainant.
See, and that just screams to me, what's the difference? Why just this one person versus everybody else that's accepted versus this one person?
So I get
One
what you're
case.
saying. You have the question of.
Because that's the first thing that pops in my head as a question.
Right, so I see what you're saying. You have the question of what was specific about the complainant where they treated her differently. What you have to remember as a member of the board, you're only looking at discrimination. So, evaluating all the evidence that we have, can you say that they refused to accept rental assistance funds? I, as the investigator, looking at what happened before and after her, there is no evidence to show that lawful source of income was the reason why that the eviction was filed.
Then why was it?
Well,
I can only look at discrimination.
I'll share this. So, first of all, thank everybody for their perspective. That was a good one too, page 3. So that was a good one. I'll share this and I may have misheard her. The complainant has already said that, and forgive me if I misheard this, that respondent didn't renew, or she didn't choose to renew, or the respondent didn't choose to take her ERAP because of a counterclaim. That's what she said. So it's not to do with lawful source of income,
That's what they said.
But, yeah.
right?
They
So,
said it.
so they're saying it's not a counterclaim. She said she wasn't going to renew anyway with them. All right. So the issue again today is chapter 8.
But there's a lot that
Lawful-
happened before that.
That's not what we're here though to look at. We're only here to look at chapter 8
But
as
no,
it
but
pertains.
that's what led us to what is going on.
I get it. It's inquisitive. There's a lot of questions, but chapter 8 is the ruling document for us. And the issue is was she discriminated against, and were people in her similar situation discriminated against? The evidence of record points to the answer to that being no. Is there a reason why the respondent did not renew her? I agree with where you're thinking. Yes, there probably is a reason. The issue is as though that's not in our purview to deal with at this moment.
Right. The only issue I keep going back to is that there are counterparts cases that you're looking at in the same process as the complainant, however many cases before or after. And they're in the same process, not denied, not approved funding yet. The complainant is served an eviction. These are not. That's something I'm not understanding.
But those individuals received rental assistance as well.
But
They were in the same
during the
situation.
process, when she received an eviction, when these people were in a process, these other cases, they did not. Why?
But they received rental assistance as well.
Eventually, they didn't even allow this case to get
There
to
was
that
an
point.
opportunity where the respondent could have filed an eviction, but they didn't. So when looking at all the evidence of record, that points towards this not being related to rental assistance. Did you want to say something, Michelle?
If I can just comment, the job of the board and the investigator is not to ferret out the reason why the respondent did or did not do something. It's to determine whether discrimination occurred.
But that's
Based on the evidence that the investigator found here, looking at the comparators, this company did not have a pattern of discrimination. In fact, they took steps to accept that money. So that leads to a conclusion that discrimination was not the source for denial. And I'm just trying to emphasize the point that at the end of the day, it's not your job to have a reason for why they denied it. I mean, they can certainly posit that, as the claimant is saying, but it's not imperative upon this board to have a solid reason other than that there's no showing of discrimination.
Sure, and I appreciate that, and thank you, Michelle, for making that clarification. For me, that's where I'm seeing the discrimination, though. And maybe my misunderstanding of the written, law as it is, maybe that's something I would like to revisit, because that's what's clearly screaming in this case for me. That's all, when you have the comparatives and you have this other case, they're not the same, and then they're the same phase and being treated differently. That's where I find the discrimination. I don't know if I'm seeing that right, but that's my perspective of reviewing what information we've been given.
What I'm hearing is that if they take ERP funds, they take ERP funds.
I was gonna say, can we go ahead and go
You wanna
through
go?
the rest
Sure.
of this and then take it to the board to make a decision?
Okay. So getting back on track. But that's good discussion. Thank you, everyone. I truly appreciate that. All right. So the Equal Opportunity Director has determined that there is not sufficient information that would lead an impartial observer to believe that a discriminatory practice has occurred.
I think, can you go back to 3? Read and start from 3.
Oh, okay. My apologies. Let me put a space here so I can see. So I'm to inform the board, now ready to vote, that you only may consider the evidence of record. I reiterate, the Equal Opportunity Director has determined that there is not sufficient information that would lead an impartial observer to believe that a discriminatory practice has occurred. You should vote aye if you agree that there is no reasonable cause to believe that a discriminatory practice has occurred. You should vote nay if you believe that further investigation is deemed necessary. The board shall specify the areas of further investigation if by 3/4 of majority vote, further investigation is deemed necessary. I'll take a motion from the board.
I motion to accept the compliance investigators' calls for dismissal.
All right. Let me take a vote. Let me ask for a
Do
vote.
you have a second?
I'll second that.
I thought we were doing
Yeah.
a yea or nay.
Yeah, you have to ask if you have a second, and then you go to the
Okay, all in favor, say aye.
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 Opposed, say nay. Nay.
The board has determined that there is no reasonable cause to believe that discriminatory practice has occurred, and I shall dismiss the complaint. This concludes today's business as it relates to complaint of discrimination of EO-3-2022-07. The vote was 3-1, with the vice chair in dissent.
Okay, the board has voted that there is no reasonable cause to believe that a discriminatory practice has occurred.
You can go on to the rest of the agenda.
All right, do we have any new business discussion items?
None?
None? Do you have board member comments? Anyone?
I guess I would like to say that although I did find the last case we just voted on confusing at times, I do just want to say that it did come back to looking at the comparators and deciding, could I tell there was a pattern in the respondents' actions? And I just want to reiterate on record that I did not see a pattern.
Anyone else for comment? All right, our next board meeting date is November 16th, 2022.
I do want to add that meeting will be in the basement in room. You'll receive an email, I believe it's room 19, but it will be in a different location, but within this building, on the basement floor. That's all. You'll have to get the motion for adjournment.
I'm writing my notes.
Okay.
These are the things I don't know. All right, do we have a motion to adjourn the meeting for today? I'm sorry? Motion to adjourn. Do I have a second?
Seconded.
All right. Meeting is adjourned, 6:15 PM. Thank you, everyone.
Yes, you said the time. Thank you.
See that?